Hello, everybody. Welcome back to Health Law Simplified.
Hey, Sandy. Good to see you.
You too. I think this is our first time doing videos, so this is an adventure.
Yeah, for sure.
So today we're going to be talking about a massive case in the Medicare Advantage world. The ruling by the federal court in Texas striking down a CMS rule governing how the agency does risk adjustment data validation audits, so RADV audits. We've been talking about those for the past several episodes. But before we get into that, I wanted to start with something a little bit more upbeat. We've talked about this before, we do positive focus when we start our weekly firm meetings on Mondays, and we wanted to bring that to the podcast. So, Elizabeth, what's your positive focus today?
Well, last night I got a little package, as I often do, on my porch, and it was so sweet. It was a quarter zip from a client that we spoke at their legal department retreat. And they sent this cute quarter zip sweater with their company's name and legal department on it, and it warmed my heart. And my husband works in healthcare, and I tell him very little about what I do or who I do it for. But I think once somebody sends you a shirt with their name on it, you can tell. And he's like, "You work for them?" And I'm like,
Ooh.
"Yes, of course I do. Who else would they go to?" So that was fun.
I got the same package last night,
Aw.
and I felt so good. There was a little bit of a funny story because we thought it was a birthday present for someone else in my family based on timing, and then they opened it and they're a quarter zip from the legal department. And I grabbed it and said, "That's mine." And it's like such a nice material.
Yeah, it's great. Great.
That's a good one.
Yeah. How about you? Are you using the same one, or do you have your own positive focus?
I have my own. This is a little bit of a brag, but I just did a marathon last week. Last
Woo!
weekend, I've been training for it for many months, and it was a beautiful day. Got a chance to see a part of my state that I haven't spent much time in, up in Grand Rapids, Michigan, in the beautiful fall weather. So that was something I'm very proud of and still riding the high of.
I am very impressed with
Thank you.
anyone who runs a marathon. Congratulations.
Thank
It's
you.
really great.
So, more good news, at least for Medicare Advantage plans.
Indeed.
Today's topic, Elizabeth, can you just at super high level tell us about the recent court ruling affecting RADV?
Yeah. So a Texas district court ruled in Humana's favor and granted their motion for summary judgment, vacating a 2023 final rule that CMS had issued. And that rule had two significant parts. One was it authorized the use of sampling and extrapolation in RADV audits. So in risk adjustment, we'll talk a little bit more about what that means. And then the rule also eliminated the fee-for-service adjuster in calculating the extrapolated findings for risk adjustment data validation audits. So as far as the extrapolation component of the rule, it lets CMS recover suspected overpayments from audited contracts by taking a small sample of enrollees and looking at their diagnoses, and for the ones that could not be validated, extrapolating those results from the sample across the entire population. And with the targeted audit, the new targeted audit methodology, there was a little more nuance to how they did that. There was a sampling frame with people who were in the plan that year with the same diagnoses. So it's not as simple as it said. It wasn't just multiplication, but in practice, it allowed CMS to recover sometimes very large contract-wide repayments based on a small sample of audited cases. And then the second component was the rule eliminated the fee-for-service adjuster. In the context of RADV audits, CMS had previously used this adjuster in deciding how much it was owed in the audits to account for the differences in documentation of codes between original Medicare and Medicare Advantage. When applied to MA RADV audit findings. This adjuster had the effect of lowering recoveries, so it was favorable to MA plans. The final rule in 2023 eliminated that, and that is part of what was vacated by the federal court.
Thank you. And for those who are listening who are probably familiar with extrapolation as a concept, but maybe aren't as familiar with the fee-for-service adjuster, which has not gotten as much attention in industry news in very recent years, don't worry. We're going to get into that in a little bit and explain, how it worked and why it was challenged in this litigation. But first, I just want to, pull back the curtain a little bit and say this case and the timing of it really surprised me.
Yeah.
I almost couldn't believe it. We've known this litigation was out there and that there was some uncertainty around this 2023 final rule, but these cases take so long to wind their way through the courts. And previous litigation challenging other instances of CMS collecting overpayments have not been as successful. So I was very surprised, especially by the timing. And so I was hoping that you could speak a little bit to Elizabeth. Why is this ruling such a big deal in the industry at this particular moment, fall 2025?
Yeah, I think it surprised a lot of people. And what the context, and we've been talking about this on the podcast, earlier this year, CMS announced a very aggressive plan to ramp up RADV audits. It stated its intention to audit every single MA plan on an annual basis and clear a backlog of contracts, so that it would, in 2026, have audited all contracts for the payment years 2018 through 2024. And that's unprecedented in terms of its scope from the RAVI audits that we've seen to date. And if you're interested in learning more about that, we covered that audit expansion in our episode 6 this year. So feel free to go back to that and get some background information if you haven't already heard about that. But a big piece of CMS's audit plan was that it was going to extrapolate its findings. And we, along with others, had predicted this could lead to really significant audit findings in the millions and tens of millions per audited year, and that frankly it could put MA plans, especially smaller and mid-sized plans, out of business, or just tip the scale in a time when a lot of plans are evaluating, do they want to stay in this marketplace, tip the scales in favor of potentially leaving Medicare Advantage. And so we knew also just from CMS's announcements that it was looking at this as a revenue generator, a way to recoup funds that had been previously paid to MA plans. So that all could still happen. Something we want to point out is that the court vacated the rule based on procedural deficiencies. So it undermines the use of extrapolation in the short term being probably the next few years, but it didn't, we'll get to this more later, it didn't substantively say that extrapolation and the elimination of the fee-for-service adjuster are improper, just that the way this rule was put out didn't, meet all the requirements.
Yeah, thank you for clarifying that. I think that's really important because although the impacts of this rule are huge in that extrapolation is now really not permissible under operative CMS rules, as I read the opinion, the court did not say that CMS is per se barred from extrapolating audit findings or that CMS is required, for example, to use a fee-for-service adjuster. So you mentioned that
Agreed.
that this decision was really a procedural decision.
Mm-hmm.
Can you explain a little bit about what the court's rationale was?
Yeah, so they didn't get to the merits of extrapolation or the use of the fee-for-service adjuster. They didn't suggest that those things are prohibited, like, as you said. What they focused on was the procedure for the issuance of the 2023 final rule. There was a big gap between the proposed rule and the final issuance of that rule. The court pointed out that CMS used different justifications in the final rule than those discussed in the proposed rule, and it didn't follow the proper notice and comment process. So CMS now has the option of going back, issuing a new proposal, and curing those procedural deficiencies and trying to reissue something allowing extrapolation and eliminating the fee-for-service adjuster. But then, of course, we would anticipate that Humana already has its substantive arguments against those features, and we would anticipate this getting back into litigation and that taking, several more years.
Indeed. For the admin law nerds out there, I believe it was the logical outgrowth doctrine that the court relied on, in that the rule that CMS ended up finalizing was not a logical outgrowth of the rule and the rationale that was originally proposed. So that's I think it's interesting. It's a little bit in the weeds for this podcast though.
Fun fact, Sandy, when I was in law school, I planned on being a securities lawyer, which I was for a short time. I did not take healthcare law or admin law.
Oh, yeah, nobody goes to law school wanting to be an admin lawyer.
I've caught up. It's fine. Don't worry. Don't be afraid. But yeah, anyway. So I don't think I get to call myself an admin law nerd. At this point, I think I call myself a health law nerd.
Did your school have a health law course?
It did. It had one.
Yeah.
It had one.
I don't know that. Yeah. Health law, I will confess, was not on my radar either. But,
I love it. Love it.
Thank goodness we landed here. I think I said something like really untoward, like, if I ever end up as an admin lawyer, because I did take an admin law course and hated it.
I took random secured transactions, bankruptcy. I loved code courses. Anyway, I digress.
Good bar prep for any future lawyers listening. That is good bar prep. So I did want to just flag really quickly that the argument that the court found persuasive that CMS didn't follow notice and comment was not the only argument that Humana raised. It raised a couple of alternative arguments that CMS did not get to in the decision because it didn't need to. So those arguments are that the final rule was arbitrary and capricious because CMS changed its policy on the fee-for-service adjuster without adequate explanation. So the court didn't get to that. And then the second argument that was not addressed was the argument that CMS abused its discretion in applying the new policy retroactively, going back to payment year 2018, based on a misinterpretation of the Medicare statute. So we might see arguments of this nature rear their heads again if CMS either appeals or tries to resurrect this rule in some way. And I think, there certainly will be a substantive discussion at some point about the interpretations of the Medicare statute and what is the full extent of CMS's authority to extrapolate, to apply a fee-for-service adjuster or not, to make changes to RADV methodology retroactively, et cetera.
Yeah, so interesting.
So I did want to get into the fee-for-service adjuster a little bit, just because that is the bulk of what drives the court's opinion in this case. That there's really very little discussion of extrapolation in the case. It was really the finalization of the removal of the fee-for-service adjuster and the justifications for that drove the discussion. So I wanted to break that down so that our listeners understand why the court came out the way that it did.
Before we get into that, something that's interesting to me, even though I didn't take admin law, just the politics of this. So the proposed rule was in 2018. So that was first Trump administration leadership oversaw the authoring of that proposal. And then the finalization was in 2023 during the Biden administration. And this is a lesson to regulators too. If you're finalizing something, you might want to stick with more of the justifications. And, they kind of had their own perspective on it, which is normal for a new administration. But then because they didn't reissue the proposal, they kind of got burned for that.
Yeah, that's a really, really good practical takeaway. And from the industry side, a basis to challenge these rules that we don't feel have provided adequate notice to our clients.
Mm-hmm. So next time, a new administration should say, our predecessors were right on the money with this. We agree.
Yes.
And we're finalizing it right now because we don't want to have to reissue the proposal.
More bipartisanship. I love it.
Oh, yeah. Mm-hmm.
So we have to go all the way back to 2010, pre-2010, when CMS first started doing RADV audits. So for the first few years, CMS was only collecting payments corresponding to individual diagnosis codes for the enrollees that were included in the sample that was audited.
And we say collected. Trying to collect.
Yeah.
Like, has anything ever been collected for this?
That's a good question. I don't know if pre-2010 was collected. It's possible.
We can look that up.
Post-2011, I think those have been hanging out there for many, many years.
Yeah.
And then in 2010, CMS announced that it was going to start calculating, not collecting, estimates of the payment error rate for the entire contract population. So essentially, CMS said, we're going to start extrapolating. It's going to be actuarially significant. It's going to be an appropriate extrapolation, but this is what we're going to start doing. And the industry and Medicare Advantage plans, including Humana, gave feedback to CMS that this approach didn't make sense from an actuarial perspective because CMS was relying on two different sets of data that are really not comparable when measuring payments corresponding to a given diagnosis. So CMS is looking at Medicare claims data, which is never validated. There's no RADV audit on Medicare fee-for-service claims data. So presumably there's diagnoses in that data that are not supported. There's an error rate inherent in that. And then Medicare Advantage claims data, which is validated through the RADV audit process, and unsupported diagnoses are pulled out of the data. And so the argument raised by Humana and others is that this imbalance resulted in Medicare Advantage organizations being systemically underpaid. And CMS found that persuasive at the time, and in 2012 introduced something called the fee-for-service adjuster. And this adjuster accounts for the difference between these two sets of data and ultimately makes an offset to the payments that CMS recovers during an extrapolated RADV audit. Says we recognize that the data, the fee-for-service data we're comparing to is going to have an error rate, so we are going to adjust the overpayment that we've calculated downward so that the payments to MA organizations are actuarially equivalent to Medicare fee-for-service payments. And why is CMS and everybody so concerned about fairness between MA and original Medicare? Well, that is a statutory mandate of actuarial equivalence. So the Medicare statute requires payments to MA plans to be functionally, actuarially the same as payments under the original Medicare program. So everybody's happy. This fee-for-service adjuster is used from 2012 to 2018 on RADV audits conducted for those payment years. And then in 2018, CMS proposed the rule that would do away with this fee-for-service adjuster. And at the time, as you pointed out, Elizabeth, this was under the first Trump administration. CMS offered a rationale and said, this proposal is unfair to plans that are not audited because a plan that is audited is getting the benefit of this fee-for-service adjuster in that the amount that they're repaying is reduced, but there is no similar adjustment made on the front end to plans when they're getting paid, when they first get their capitated payments. So unaudited plans are not getting the benefit of this adjuster. I'm not going to opine on whether that rationale makes sense. I'll just say that was the justification that was proposed. CMS invited comment on the rule, as they're required to do. The industry objected strenuously to the removal of the fee-for-service adjuster.
I'll go on record to say I don't think that rationale makes sense.
Thank you.
But
right, because those unaudited plans they're not
getting audited.
Right. I guess audits are unfair.
Yeah. And I guess it's based on the premise that somebody out there is doing it all perfectly, as if that was a thing that could happen. But okay, go ahead. Sorry.
Well, now with auditing everybody, as CMS is trying to do, perhaps that fairness issue is resolved, not to do their work for them.
Ooh, I like that. I like that. Yeah.
Years pass. This rule is just a proposal for 5 years. CMS finalizes it in 2023, and we get a new rationale. The rationale offered by the CMS operating under the Biden administration is that the RADV audits do not have to comply. They're not required to comply with the actuarial equivalence mandate, and that the fee-for-service adjuster is no longer necessary because CMS already does something called a coding intensity adjustment when it's doing its RADV audits. There's a lot of reasons, I think, for how it arrived at this rationale. There's some historic litigation involving United Healthcare and the actuarial equivalence mandate. Again, not opining on the strength of this argument, but it does have a logical sense. But it's different. It's different than what CMS originally proposed. And so nobody got the chance to respond to the new justification that CMS ultimately relied upon. So it's this switcheroo that CMS pulled, that is what underpins the court's ruling that CMS violated the APA's notice and comment requirement, which requires the finalized rule to be a logical outgrowth of the proposed rule. And thank you for coming to my presentation.
Well, there was a lot of blowback to the initial proposal, which I assume was part of the reason it took, 5 years to issue the final rule. And it was kind of speaking of surprises, it was a surprise when it came out because that proposal had just been sort of lingering out there. I don't know why they didn't repropose, but anyway, they didn't consult with me. But did the comments address whether actuarial equivalence applies to RADV audits? Was that legal question sort of analyzed in the rulemaking?
That's a really good question, right? Because it gets to the substance of this argument, which is we weren't allowed to respond to these arguments that actuarial equivalence does not apply to RADV audits. And CMS pointed out in the briefing in this case, well, actually, there were a number of comments that touched on this issue. These stakeholders knew. They knew that they had to make that argument, or they thought of it and raised the issue. Mm-hmm. But the court ultimately found that that wasn't enough to persuade it that MA plans impacted by the rule should have foreseen CMS finalizing the rule on that basis. And I think the court's language here is very telling regarding its thoughts about how CMS approached the issue. It said, even if a few members of the public happen to divine the government's unspoken thoughts, comments such as these do not satisfy the government's obligation to afford the general public an opportunity to respond to a clearly stated proposal.
Ooh, somebody had a sassy law clerk, right? Drafting there.
Yeah, they get to have fun with it.
Even if a few members of the public happen to divine the government's unspoken thoughts.
Yeah, isn't that good?
Did you? Oh, okay. This is a little up. But did you ever listen to Garrison Keeler when
Of
he had the
course.
English majors segments, and
Of
it was like
course.
your major is an English major? I was an English. That law clerk was an English major,
That's
and I'm
probably why I
sorry
loved
to
it.
burst the bubble of law clerks' right opinions. I digress. I love it.
That's a secret.
Happen to divine. Yeah.
Especially, it kind of makes me laugh because as a former litigator, we are trying to divine. Actually,
Mm-hmm.
even now, clients ask us all the time to divine what CMS is going to do, and it's part of our job. But
Yeah.
that's why we have the APA. Notice is part of the government's duty when it's regulating, and the court said here, CMS did not satisfy its burden to notify the public with specificity
Mm-hmm.
that it was considering finding the actuarial equivalence requirement inapplicable to RADV audits. And I think that's really fair. CMS also made a last ditch argument that it had no obligation to seek comment on its statute because this is just a statutory interpretation. And the court said, no, 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 this is not just statutory interpretation. When your new rule is completely irreconcilable with your old rule, it has to be subject to notice and comment. It's not procedural. And so this change on the fee for service adjuster and also on actuarial equivalence, it's just such a large change that CMS is bound by APA procedures.
So interesting.
Yeah, it really raises questions about whether or not CMS's expansion of RADV audits earlier this year, which was not done by notice and comment, is a big enough
Mm.
change that it should have warranted a rulemaking.
Well, we follow, various strains of litigation processing through the courts right now involving Medicare Advantage regulations. Sandy, how do you think this opinion lines up with some of the rulings we've seen in the last few years about things like broker compensation, star ratings, other topics for Medicare Advantage organizations?
Thank you for asking that because this case actually lines up really neatly with the earlier rulings that we've seen. And I think the broader trend that all of these decisions demonstrate is increased scrutiny over CMS's rulemaking authority and procedural compliance. There's been a lot of talk about Chevron deference, which is no more, after Loper Bright. CMS did try to invoke Loper Bright in this case. And when it argued that its failure to adhere to the APA was harmless because its interpretation of the Medicare statute was the best possible reading of the statute. And the court rejected that. It said, these plans were indisputably harmed by the lack of meaningful dialogue regarding the costs and benefits of surprise changes. And the court was really not persuaded that CMS can just not comply with the APA. And this trend towards increased scrutiny over CMS is also evident in the case overturning CMS's broker compensation rule, which we talked about on an earlier episode, and also the decisions over the last couple of years in which plans have successfully challenged CMS's star ratings methodology, a number of which led the court to order recalculations of plans' star ratings. There have been a bunch of star ratings cases. Some have been successful, some have not been. The ones that have been more successful have been the ones where the plans are able to argue that CMS exceeded the scope of its own authority as evident by the regulations in the regulatory text and not just, CMS made a mistake in the math. Those cases that are more fact-based have been less successful.
Interesting.
So these rulings together, I think what they show that what courts expect is procedural rigor, fidelity to the statute. CMS needs to follow proper notice and comment procedures, especially when making significant policy shifts. That was what happened with the broker compensation case. When CMS decided that it was going to cap administrative payments, it was such a huge shift that there needed to be adequate rationale included in the rule. And judges are really pushing back on CMS's attempts to expand its reach beyond what is explicitly authorized by the statute. And courts are also starting to be wary of CMS applying new rules retroactively, especially when the industry's relied on the old guidance.
That's speaking of bipartisanship, expanding regulatory authority beyond what is explicitly allowed in a statute, that's bipartisan.
Yeah, absolutely.
You can count on that. Whoever's in the White House, that will occur from what we've seen. Yeah.
And we'll probably see more of it.
Yeah, for sure.
So I want to get back to, practical implications of this ruling for MA plans. Elizabeth, the threat of extrapolated audit findings with or without a fee-for-service adjuster has now been hanging over the heads of MA plans for more than a decade. What do you think is going to happen next with this case and with extrapolation generally?
Yeah, I would say it's still hanging over their heads. And the risk of that, the magnitude is still very high, but the likelihood and the immediacy of that risk has been pushed out at least a couple years. So HHS is likely going to appeal the ruling because of the substantial financial impacts that it would have on the planned RADV audits and subsequent collections.
Let me cut you off real quick. CMS has 60 days from the September 25th decision to appeal. So we've got a few more weeks. Go ahead.
Yeah, thank you. So that'll be interesting. Another tack they could take, either in tandem or as an alternative, is they could revise and reissue either a proposed rule re-proposing this or a final rule based on the original 2018 justifications. I'd be surprised if they reissued a final based on those because they have different perspective and they know almost certainly this is going to be contested in court. So I would predict they would reissue a proposal, but we'll see. We don't know which way they'll go. If a rule is eventually finalized, it's likely going to be subject to further legal challenges. I will say Humana is really carrying the load for the industry on this by litigating this so intensively. I don't have reason to think they wouldn't continue doing that. We'll have to see. In any case, these issues are going to be tied up in the courts potentially for years to come.
I agree. It's going to be years before we have any kind of resolution, which is a space that plans have been operating in for a long time in risk adjustment, right? That uncertainty. So, that brings us to the question that we get asked as lawyers every day. How does this affect an MA organization's legal and financial risk?
Like I said, I don't think the magnitude of the risk goes down. It's huge, especially if we know CMS's intention is to do RADV audits on every plan for every payment year and try to extrapolate. The likelihood of that very high magnitude risk got a little lower because of this challenge, I would say, and we expect further delays. So it's sort of this long trail of potential liability for payment years going back, many years. It's a weird environment in which to do business, but it's something that MA organizations have had to grow accustomed to. So I would say the risk is still there, but it's more remote.
And I just want to note that we've heard, that plans who are currently undergoing RADV audits for payment years 2019, those are still going on.
Right.
They were already started and those are continuing. And, there's a big question now. What methodology is CMS going to use? Because the methodology outlined in its memos governing these audits is no longer valid technically. So I think one consideration is documenting to CMS, if your plan hasn't already, that any extrapolation beyond payment level errors would not be valid at this point in time, just to preserve your arguments down the line.
Yeah, that's a good point.
Do you think risk adjustment outside of RADV audits is still a top of mind issue for plans, Elizabeth?
Absolutely. And it always will need to be as long as this payment structure is in place. Plans should still think about reviewing their risk adjustment processes for legal risk in light of the ever evolving environment, review their documentation. What are they? Self audits, not just duplicating what they'd experienced in a RAVI audit, but comprehensive reviews of their risk adjustment programs to look for sources of risk, including the way they communicate about risk adjustment and coding to providers and vendors and other audiences that contain potential whistleblowers. They will never be done doing that risk management work along with their risk adjustment, which they have to do to make sure they're getting the right level of payment for the populations they're responsible for.
And this particular CMS, may be very amenable to being satisfied with that type of self-policing. I think Dr. Oz very recently indicated his preference rather than to regulate would be to give MA organizations space to quote unquote self-correct some of the practices that have been under scrutiny, including coding. So, to the extent that you do undertake these activities to review your practices and do self-audits, document those and consider, transparency with your CMS account manager if and when you're able to communicate with them after the shutdown.
Oh, right.
Around your findings.
Once they're back. And I do think risk adjustment data validation audits will continue in some form, whether as intensively as announced or in some other form. But this whole topic is never going to go away for MA organizations and their business partners.
Yeah, and it's worth noting that the congressional interest has not gone away. And this ruling may even lead to renewed activity or motivation to pass a law.
Yeah, there's been, MA is always in the press, but did you see the John Oliver?
I did because you sent it to me.
Yeah.
Thank you.
It's very in-depth and, of course, very critical of the industry. It focuses on Medicare Advantage. They did their research pretty thoroughly. I think it's going to get quite a bit of attention, along with other, was it the Kaiser family? That you sent that to me, the KFF study about networks in Medicare Advantage and the relatively fewer numbers of providers that MA members have access to, according to their study. It was 50% of original Medicare providers. So, we will never see the end of congressional scrutiny and more rulemaking and potentially legislation in this space.
It never gets boring.
Nope. This is great.
Yeah.
Enjoyed talking to you. Thank you.
Yeah, thank you. See you next time.
Bye, Sandy.
Bye.
If you enjoyed this episode, please subscribe wherever you get your podcasts. And if you want to find out more, go to strategichealthlaw.com. This podcast is for informational purposes only and should not be considered legal advice. If you need legal advice on any topic we've covered, please consult an attorney with appropriate experience in health law. Our music is Galaxy Love by Johnny Duke. Until next time, thank you for listening to Health Law Simplified.